I'd like to thank everyone for taking the time to watch our module presentation as Municipal Affairs starts the 2025 municipal election training season. As a bit of a disclaimer before we start, this presentation does not constitute legal advice. It is only information about the processes and legislative provisions returning officers need to be aware of. Questions about how the legislation applies to specific facts should be directed to your legal counsel. Before we get into Module 1, I'd like to talk about the 2025 training as a whole. The 9 returning officer modules will be delivered over the course of several months, and modules will be delivered in pre-recorded videos that will be posted to the Municipal Affairs website. Municipalities will be notified by email when new modules are made available. The new format does not mean that you won't be able to ask us questions. Of course, we encourage you to contact us at Municipal Advisory with any questions or concerns you may have, and we'll do our best to get you the information you need. Module 1 kicks off our 2025 election training sessions, and Module 2 will be made available before the end of the year. The remaining modules will be rolled out over the course of 2025. Module 1 will cover things you need to consider as you begin planning for the election, including applicable resources and legislation. It will also cover the roles and responsibilities of returning officers, substitute returning officers, the Minister of Municipal Affairs, municipal councils and CAOs, who under the Local Authorities Election Act are also referred to as the Secretary, and we'll touch on some preliminary planning considerations, including what you might need to think about now given your 2025 budget considerations. And of course, I'll be highlighting some of the amendments to the Local Authorities Election Act in light of the recent proclamation of the Municipal Affairs Statutes Amendment Act, otherwise known as Bill 20. So let's talk a bit about resources and legislation. Most of you are familiar, I hope, with the Municipal Government Act and the Local Authorities Election Act. Both pieces of legislation are available through the King's Printer, and I can confirm that the King's Printer and CanLII have both been updated with the most recent versions. In addition to the Local Authorities Election Act, there is also the Local Authorities Election Forms Regulation. I know all of you are anxiously awaiting the updated forms regulation, as we are. Unfortunately, all I can confirm at this point is that the regulation is coming. Municipalities may also have their own election bylaws. I encourage municipalities to see if a single bylaw exists or if several bylaws have been passed relating to elections. A review of these bylaws should occur soon, if it hasn't already, to ensure that it is still relevant and still accurately reflects the election processes you want to see in place for 2025. And of course, Municipal Advisory is available to help you with any questions that may arise during the election period. Please do not hesitate to call or email. In addition, please make sure to visit our website for more election information and resources, including the updated Returning Officer Manual. So we've talked about the legislation that applies in local elections and the resources that are available to you. Now let's look at some of the different roles and responsibilities for those who are involved in the election. When preparing for the election, it's always important to understand the various roles of the people involved. Let's start with the returning officer. The returning officer has a variety of responsibilities leading up to Election Day. Section 14 of the LAEA outlines the duties of the returning officer. In addition, Section 13.1 requires that the returning officer be independent and impartial when performing their duties. Essentially, this means that returning officers cannot favor one candidate over another and cannot influence voters in any way. Some of the main duties of the returning officer include the appointment of election workers, including presiding deputies, constables, and any other persons that the returning officer requires. Establishing the voting stations, designating deputies to work at the voting stations, logistics, things like ordering supplies, ballots, ballot boxes, and ensuring that the appropriate supplies are delivered to the voting stations, giving notice of nomination day, receiving nomination papers from prospective candidates, giving notice of election day, and doing all things necessary for the conduct of an election. Returning officers will respond to questions from the public and prospective candidates regarding eligibility, election processes, signage requirements, campaign financing, and third-party advertising. Returning officers must ensure that the election is conducted in a manner that is fair and transparent. Prior to undertaking any duties, returning officers should make sure to sign the oath of returning officer, which is included as a form in the local elections forms regulation, local authorities election forms regulation. Next, the substitute returning officer. A substitute returning officer must be appointed by council resolution. The appointment of the substitute is done at the beginning of the process in case the returning officer is unable to fulfill their duties. Typically, the returning officer and substitute are appointed by council resolution at the same time, along with the passage of any other election-related resolutions of council. I'll speak more about council resolutions in an upcoming slide. The Minister of Municipal Affairs. The Minister of Municipal Affairs has the overall responsibility for the Municipal Government Act and the Local Authorities Election Act. The Minister may give special directions that govern the conduct of the election, but will only do so if the LAEA and its provisions are deemed insufficient. These powers are extraordinary and are not exercised lightly. Also, with the Municipal Affairs Statutes Amendment Act, amendments to the Local Authorities Election Act, the Minister now has new powers under Section 6.1, which allow the Minister to extend or adjourn voting or take any other action the Minister considers appropriate if, in the Minister's opinion, an emergency, a disaster, or an unusual or unforeseen circumstance is likely to have a significant effect on the conduct of an election or the ability of electors to attend at a voting station. This too is a power that will only be used in extraordinary situations. We are aware that there's a possibility that the federal election will happen on the same day as Alberta's general municipal election. However, the Minister would have authority to change the election date if that were to occur. The Minister also requires information regarding municipal elections, for example, the official election results and the names of elected officials and their contact information. This information will be used for government correspondence and is also helpful for municipal advisors when fielding questions from residents, municipal officials, and returning officers. This information can be updated through the elections database, which is accessible from the same webpage as our election resources. Municipal councils. Municipal councils also have a role to play during an election, and as mentioned, some issues need to be addressed by council resolution or bylaw. Some of the resolutions include the appointment of the returning officer and substitute, the provision of special ballots, advance votes if the population of your municipality is less than 5,000, as well as at-home and institutional voting. I'll get into more detail on resolution and bylaw making authority in just a moment. Although the role of council is limited in the election process, their approval is required on several items that the returning officer will then rely on and use throughout the election. However, once the necessary resolutions and bylaws have been set, the returning officer is responsible for the overall conduct of the election. The CAO has prescribed duties under the Local Authorities Election Act as well. These duties still exist even if a returning officer has been appointed by resolution. The CAO is responsible for providing information and assistance if requested by the returning officer. The CAO is also responsible for the election materials upon declaration of the results and for the ultimate destruction of the election materials in accordance with Section 101 of the LAEA. Now we'll turn to some preliminary planning and other considerations. Let's start with hiring. Section 13 of the LAEA allows council to appoint a returning officer. Council should decide whether this person will be appointed internally or whether the returning officer will be contracted externally. The decision is up to each individual municipality. Remember that if the CAO will be the default returning officer, Council still needs to pass a resolution appointing a substitute. Once appointed, and once the oath has been taken, the returning officer is responsible for appointing presiding deputies, constables, and any other election official they think may be needed. Constables can be appointed to help maintain order at the voting station and may be asked to help deputies. It's a good idea to include in your election plan a conversation with local law enforcement ahead of Election Day. Election Day will be incredibly busy, so if something happens and you need to call police to the voting station, it will be helpful if they know that the election is happening, so they won't be caught off guard by the call. Also, any substitute deputy or constable appointed needs to sign their statement and should do so as soon as possible to ensure that they can conduct election business. Materials. What do you actually need for Election Day? The reason we talk about this now is because materials may have budget implications. The standard items will always include voting screens, ballot boxes, forms, and ballots. For ballots, it's a good idea to be safe and order enough for all eligible electors. It's unlikely you'll need all of them, but you don't want to run the risk of being short. The most critical form will be the elector register, which you will need for any elector who does not appear on your permanent electors register. Also, the form numbers have probably changed, so please ensure that you check the updated forms regulation once it becomes available, and don't rely on old forms. Again, it's always a good idea to print more forms than you think you'll need. In addition to the elector register, you'll also want to have instructions for electors, statement of voucher, presiding deputy's certification and statement on completion of ballot count, statement of scrutineer or official agent, statement of interpreter, note of objection to a ballot, ballot account, and result of vote. Generally, make sure to take a close look at the forms regulation and make copies of any form you think you might need on Election Day. You don't want to be caught off guard. You'll also need other supplies, including pens, pencils, and envelopes. If you start to think about these necessary supplies now, it's one less thing to worry about as Election Day gets closer. Agreements. Some municipalities enter into agreements with their respective school boards for the purposes of the election. The Local Authorities Election Act provides for these agreements under sections 2 and 3. These sections specify that an elected authority may hold an election separately or in conjunction with another elected authority in the same area and may enter into an agreement through resolutions of the elected authorities. The agreements must state which elected authority is responsible for the conduct of the election, and that authority must adhere to the processes prescribed in the Act. The agreement must state which elected authority and returning officer is responsible, must require each elected authority to appoint a returning officer, and may provide for all other matters necessary for the conduct of the election. The elected authority responsible for the conduct of the election has all the rights, powers, and duties of the elected authorities that have entered into the agreement respecting the conduct of the election, including the power to pass bylaws and resolutions, excluding those under Section 27. Other agreements that you may need to consider include rental agreements for voting stations. Depending on the size of your municipality and the types of locations available to you, you may have to consider voting stations sooner rather than later. It's a good idea to start looking at these options now and secure your voting station locations as soon as possible. And just a couple of voting station tips. When considering appropriate voting stations, remember to look at things like accessibility, size of the room, potential layouts for your voting station, and voter privacy. Keep in mind that if you're using schools, you'll need to enter into agreements with them. We have heard that some schools can be reluctant to allow for their use during the election. So look into this right away so you have more time to figure out an alternative if necessary. You may need to negotiate with the schools or the school division, or speak with your neighboring municipalities to determine what they might be doing and get some different ideas. Also look for a space where your election workers can take a break and where you can bring in food and coffee. Prospective candidates. You should also consider putting together prospective candidate packages. Some municipalities choose to do this, and others choose to simply do nomination packages, but a nomination package would be the bare minimum. What to include in a package for candidates, aside from the necessary forms, is up to you. Things that you may want to include are council and committee meeting calendars, dates of any training that is being offered, municipal affairs resources, including the candidate handbook, community profiles that may be available, and maps of the relevant municipality or ward. Again, these are just tips for you to consider as you plan for the election. You should also speak to your colleagues in other municipalities to get some ideas for what's going to work best for you. Municipal councils will need to pass resolutions to allow for certain election processes. I recommend reviewing all of these sections to ensure you understand the possible resolutions your municipality may pass in preparation for your election. The appointment of the returning officer and substitute. Resolutions need to be passed by June 30th in the year of a general election. If an RO is not appointed, then the secretary, that is the CAO, is deemed to have been appointed. Since nominations can be received as early as January 1st, the returning officer and substitute appointments should be considered sooner rather than waiting until June 30th. With the passage of Bill 20, there are some new restrictions on who may be appointed as returning officer and substitute. Candidates for the local jurisdiction cannot be appointed, as well as the candidate's spouse, adult interdependent partner, child, parent, or sibling. Advance votes. Municipalities with a population greater than 5,000 must provide for an advance vote if the However, if the population is less than 5,000, a resolution to hold an advance vote is needed. Special ballots. A resolution is needed to provide for special ballots, and with the passage of Bill 20, special ballots may now be offered to all electors who are unable to vote at an advance vote or on election day, as long as they're on the permanent electors register or have successfully applied to be added to it. Elector assistance at home. By resolution, a council may provide for the attendance of 2 deputies at the residence of an elector during the hours of an advance voting station is open, or at other times fixed by the resolution. If a resolution is passed under Section 79, deputies may take votes at the homes of electors who are unable to attend a voting station or an advance voting station because of physical disability. Electors may request an at-home vote, and the returning officer must be satisfied that an elector is unable to attend a voting station or an advance voting station because of physical disability. Institutional voting. By resolution, or the returning officer, if authorized by resolution of the elected authority, may designate the location of 1 or more institutional voting stations.
This is a list of the bylaws that may be passed under the Local Authorities Election Act in preparation for the general election. These are discretionary bylaws, so there is no obligation to pass them. Some municipalities might choose to pass these bylaws individually, while others might choose to create a single election bylaw that addresses several of these areas. If you pass a single election bylaw, make sure that your municipality is comfortable with the requirements. As with the possible resolutions discussed earlier, we strongly recommend reviewing these sections of the LAEA to better understand the potential bylaws and whether they're needed in your municipality. The first one is Election Day. Section 11 allows you to pass a bylaw to have your election on the Saturday prior to the 3rd Monday in October. This then results in your nomination day being the Saturday 4 weeks before Election Day, rather than on a Monday. However, if there is a Senate election or referendum question, municipalities must hold their election on the designated day. Form of nomination. Section 27 sub 2 allows municipalities with populations greater than 10,000 to pass a bylaw to increase the signatures on the nomination form from 5 to not more than 100. Location to file nomination papers. Section 28, sub 1.1 allows municipalities to pass a bylaw prior to December 31st in the year before a general election to allow for additional locations where a deputy may receive nominations. Deposits. Section 29 allows municipalities to pass a bylaw prior to December 31st in the year before a general election, requiring a deposit to be filed with the nomination papers. There is a $100 maximum unless the municipality has a population greater than 10,000, and then it can be set no higher than $1,000. Before the Bill 20 amendments, a deposit bylaw could be passed not fewer than 30 days before nomination day. Death of a candidate. Section 33 allows for a bylaw to be passed, requiring an election to be discontinued if a candidate dies after being nominated. If no bylaw is passed, a notice of death is posted instead, and the election is conducted as normal. Voting station locations. Section 37, sub 3 allows for municipalities to pass bylaws prior to June 30th in the year of a general election to establish more than one voting station for each subdivision and the location of those voting stations. If a bylaw is passed, the returning officer has the authority to set the locations. Printing ballots in lots. Section 43 allows for the printing of ballots in lots. This bylaw must be passed at least 2 months prior to election day. The lots rotate through the entirety of the list of candidates so that all candidates will appear at the top of the ballot once. The intent here is that no 2 consecutive electors receive the same ballot. Voting station hours. Section 46, sub 2 allows a municipality to open their voting stations prior to 10 a.m. if a bylaw is passed prior to June 30th. The opening may be earlier, but the closing of voting stations cannot be adjusted, and stations must be promptly closed at 8 p.m. on election day. However, electors who are still in line may still be allowed to vote. Blind voter template. Section 78, sub 4.1 allows municipalities to pass a bylaw for blind voter templates by June 30th. Recently added to the LAEA is the provision for Elector Assistance Terminals. The new section 84.1 allows a bylaw to be passed by June 30th of a year of a general election that provides for the taking of the vote of an elector who is unable to vote in the matter prescribed by the LAEA by means of an Elector Assistance Terminal under specific circumstances. Counting centers. Section 85.1 allows for the designation of a counting center for the purpose of counting special ballots, advance votes, and institutional ballots. This bylaw must be passed by June 30th of the election year, and the candidates must be notified of the count center location.
There are also some bylaws that may be passed pursuant to the MGA in advance of the election. Section 143, sub 1 provides the council of a city or town consists of 7 councillors, unless the council passes a bylaw specifying an odd number of 3 or more. Sub 2 provides that the council of a village or summer village consists of 3 councillors, unless the council passes a bylaw specifying an odd number of 5 or more. Section 148, sub 1 states, the default rule is that when a municipality is divided into wards, only an elector who is resident in the ward may vote for a councillor in that ward, and councillors are elected for each ward. However, under sub 2, a council may, by bylaw, divide the municipality into wards and establish their boundaries, change the number of wards and their boundaries, give each ward established or changed a name or number or both, state the number of councillors to be elected for each ward established or changed, and eliminate wards. Under subsection 3, a council may, by bylaw, provide for councillors that are in addition to the councillors elected for each ward, are elected by a vote of the electors of the whole municipality, and are councillors for the whole municipality, not just a ward. Under subsection 4, a council may, by bylaw, provide that all councillors are nominated by ward, are elected by a vote of the electors of the whole municipality, and are either councillors for the ward in which they were nominated or for the whole municipality rather than for a ward. Section 150 sub 1 provides that the chief elected official of a city or town is to be elected by a vote of the electors of the municipality unless council passes a bylaw requiring council to appoint the chief elected official from among the councillors, specifying when the appointment is to start, and specifying the term of the appointment. A bylaw under sections 143, 148, or 150 must be passed by December 31st of the year before the general election at which it is to take effect. And again, these are discretionary bylaws. I recommend carefully reviewing these sections to understand exactly what they entail and decide if a bylaw pursuant to any of these sections may be needed in your municipality. Now let's talk about some of the Municipal Affairs Statutes Amendment Act amendments you need to be aware of as you begin to prepare for the general election. Remember, this is not legal advice, and this is not a comprehensive analysis of the amendments. These are just some of the things you need to consider in the early stages of your election preparation. Future modules will get into further Local Authorities Election Act amendments. Section 21.1 allows municipalities to require criminal record checks for candidates. A bylaw is needed and must be passed before December 31st in the year before a general election. Given the new definition of campaign period in Part 5.1, candidates will be able to accept contributions during the period beginning January 1st after the year of a general election until December 31st following the next general election. So in the case of the 2025 election, a candidate could start accepting funds from the date of proclamation, which was October 31st, 2024, as long as they have submitted their notice to run under Section 147.22 with the local jurisdiction. The campaign period then closes on December 31st, 2025. I'll talk more about this notice in the next slide. More information on campaign financing will be provided in a future module, but for the time being, please be aware of the provisions respecting the new definitions for campaign period and candidate, specifically for Part 5.1 of the Local Authorities Election Act. Notice required on contributions and expenses under 147.22. No individual and no person acting for the individual shall accept a contribution or incur a campaign expense unless the individual has given written notice. In addition, an individual who intends to be nominated or has been nominated to run for election in a local jurisdiction as a candidate must give written notice to the local jurisdiction in which the individual intends to be or has been nominated. Written notice must include the full name, address, and contact information of the individual. The address or the place or places where records of the individual are maintained, and of the place to which communications may be addressed, the names and addresses of the financial institutions to be used by or on behalf of the individual as depositories for campaign contributions made to that individual, and the names of the signing authorities for each depository. In conjunction with Section 147.22, we also have 147.221, the Register of Candidates. A local jurisdiction is obligated to maintain a register of candidates who have given notice to local jurisdiction under Section 147.22. There are no guidelines for what a register of candidates will look like, so it's probably going to require yet another Excel spreadsheet to maintain. The register must also be made publicly available in a partial or redacted form following the rules outlined in Section 28, 6.1 and 6.2 of the LAEA. The register must be made available on the municipality's website until December 31st in the year immediately following a general election. With the proclamation of the Municipal Affairs Statutes Amendment Act, Municipalities are obligated to enter an agreement with Elections Alberta to compile and revise a permanent electors register. Municipal Affairs is not involved in this process, so I would recommend contacting Elections Alberta directly if you have any questions about the register. If you do have questions about the specific section of the Local Authorities Election Act on electors registers, we might be able to help you out with that. And lastly, a new pilot project for political parties in Calgary and Edmonton is being rolled out. The new regulation provides more detailed rules governing local political parties and slates.
Now let's talk about the additional changes made to the Local Authorities Election Act through the Municipal Affairs Statutes Amendment Act 2025, formerly known as Bill 50, that you need to be aware of. These amendments came into force on May 15th, 2025. Remember, this is not legal advice and this is not a comprehensive analysis of the amendments. Rather, it's meant to raise awareness of the significant changes. Previously under Section 31, when an insufficient number of nominations was received at the close of nominations, the municipality was required to reopen nominations every day from 10 a.m. to noon for 5 additional days until enough nominations were received to fill all elected positions. Now this section states that if an insufficient number of nominations are filed on nomination day, the municipality must reopen the nominations for all 5 business days, or 5 calendar days in summer villages, regardless of whether sufficient candidates have come forward before that period expires. Previously under Section 32, if more nominations were received than the minimum to fill all vacancies for that office, candidates had 24 hours on a first-come, first-withdrawn basis to withdraw their nomination. As soon as enough nominations were withdrawn such that all vacancies were exactly filled, no further withdrawals could be accepted by the returning officer. This amended section now states that candidates have 24 hours from the close of nominations to withdraw, even if this creates an insufficient number of nominations for that office. If an insufficient number of nomination occurs this way, the municipality would be required to follow the insufficient nominations process under Section 31. Previously under Section 34, if the number of candidates for an office was the same as the number of vacancies, at the close of nominations, the returning officer would declare those candidates elected. Now under the section, the returning officer can only declare a council acclaimed after the 24-hour withdrawal period has passed. In terms of the municipality of Jasper, special provisions ensure residents of Jasper displaced by wildfires maintain eligibility to vote in and run in Jasper's local elections, provided they plan to continue residing in the municipality. Continuing with other amendments from Bill 50, enabling Elector Assistance Terminals in local elections will empower voters with disabilities to mark their ballots independently and privately. These terminals must not count ballots, not be connected to the internet, and must print out a paper ballot as required by Alberta law. Also updates to local party campaign finance rules, allowing registered local political parties in Calgary and Edmonton to transfer funds among their endorsed candidates. Local political parties will largely follow the same rules and disclosure requirements for transfers as provincial political parties. The updates also clarify the definitions of campaign expense and campaign contribution to improve transparency and consistency in reporting. Finally, the updates to the local political party campaign finance rules will increase transparency by requiring local political parties to disclose their financial records by September 30th of 2025, prior to the October election. This additional disclosure will document the contributions and expenses between January 1 and July 31st of 2025. The Election Statutes Amendment Act, formerly known as Bill 54, also includes an amendment to the Local Authorities Election Act you need to be aware of. This bill came into force on May 15, 2025. Despite it being a bill with quite a few amendments, the vast majority apply to provincial election legislation. But the Local Authorities Election Act amendment it includes is quite significant. There is only one amendment to the Local Authorities Election Act from Bill 54, and it applies to the financial disclosures of candidates and third-party advertisers. Section 147.4 was amended to improve transparency by updating campaign finance rules for candidates and third-party advertisers that accepted contributions, including from a candidate's own funds, to report by September 30th of the election year, in addition to March 31st of the following year. This new interim report will include campaign contributions and expenses of candidates relative to the period between January 1st and July 31st of 2025, and for third parties, the election advertising contributions and expenses between May 1st and July 31st of 2025. Due to the time needed to update, translate, and prepare the forms each time amendments are needed, it was not possible to amend the forms regulation to reflect the newest 2025 LAEA amendments, or to account for nuances that have now been identified. Section 26 of the Interpretation Act allows for modifications to a prescribed form as long as the changes align with the LAEA, do not affect the substance of the form, and are not intended to mislead. The date fields in Form 26 may be modified to reflect the new partial year disclosure that all candidates must complete by September 30th in the year of a municipal general election. For third-party advertisers, Form 28 may be modified to reflect the additional September 30th disclosure. Also, please note that Bill 54 put a prohibition on municipal bylaws addressing election signage, but this prohibition only applies to signage for provincial election candidates, not municipal candidates. The new expense limits regulation is also in force. It outlines expense limits for the campaign period. This is a basic overview of how the expense limits function over the 4-year campaign period. The regulation also includes expense limits for local political parties, slates of candidates, and third-party advertisers. Please note it was recently amended to say that the number of persons residing in an area at the start of the campaign period is to be determined using the 2024 Municipal Affairs Population List, found on the Open Government website.
That concludes Module 1. If you have any questions, please do not hesitate to contact Municipal Advisory by email or by phone. Please also take the time to review the rest of our online election resources, including the returning officer manuals. Thank you.